Well, to make my point, I may have to go back in the past history, because we are discussing the way forward into the legal education. So we cannot forget what the past has been. Well, it all started like this. That I look at it like this: that the dispute starts when two persons are fighting. Both of them say I am right. Now the law students are here, so I'll put it as simple as possible. So they say I am right, he says he is right. Now who's to resolve this? So in olden times, these disputes would go to the king, who was the monarch then. And he had this big darbar where he used to sit on a mighty throne, and which was placed high up the pedestal. And he would listen to the grievances of both the sides. Both the sides trusted him. They had faith in him. And ultimately, he would decide who is right and who is wrong. They would gladly accept whatever is right, whatever is the decision. Over a period of time, the responsibilities of the king increased. And therefore, slowly the system of courts came up step by step. And then we have this system where the judges still sit on the high pedestal. This to uphold the majesty of the law. And there is a purpose behind it. When two parties come, later on, due to the complexities of so many matters, when two parties come before the court, the parties and persons were unable to put forth their grievances, sometimes due to illiteracy, sometimes due to the complexity of the matter, and therefore they had to engage counsels, legally trained counsels. Now these counsels owed a duty to the court. They had to be abreast with what the law is. They had to make their submissions in a manner which behoves a counsel of that court. And that is how the practice of presenting submissions by the lawyers before the judge, respecting the courts, respecting the majesty of the court, it all started. And the judges, then and even now, the people have immense faith in them and started accepting their decisions. This is of course subject to the hierarchy of the courts, where we have appeal, then we have at the last pedestal, the Supreme Court. So this goes on for some time. Now all this is all about an open court hearing which has been going on for times immemorial. Now a time has now come whether we should tinker with this system. When I say tinker with the system, and here I completely agree with what His Lordship Justice Sonak said, we have this practice of an open court hearing. Now today, for convenience, of course during COVID times and all, we did face a lot of problems, and for convenience we have the facility of a video conferencing. And therefore, because it is convenient for the lawyers, they would appear through video conferencing. But the question is, are we really doing justice to our client by appearing through video conferencing? The reason is this. I'll put it as simple as possible. Well, there's some misunderstanding somewhere. Take a case where there's a misunderstanding between two friends. The friend will go to another friend and say, why do you have a misunderstanding? And he'll try to convince him that please try to hear me out. This is the reason what happened. Without hearing me, without doing anything, you have formed an opinion about me. Please don't do it. This is what it is. And then the friend will say either he'll be convinced or not convinced. But he has that chance, and this is called a very important concept called as an opportunity. Every person has a reasonable opportunity of presenting his case. And there is nothing more important than a personal opportunity. So this happens best when you are in a court of law. So I would implore all young lawyers, before you adopt to this video conferencing facility, please try to come to the court as far as possible and make out a case. It helps you better. It even helps the judge understand the case better. Of course, in a given case where it is impossible for you, you may resort to the facility of a video conferencing. It is there for all of you. It is for convenience. Now, the video conferencing is really working. But for whom? Now, the lawyers have gone through the grind of a lawyering. They have been part of chambers. They have been trained by their seniors. They have seen what law practice is. And thereafter, when the time came, they could easily adapt to video conferencing. But so is not the case with the young lawyers who are yet to be trained in all this. And here comes the importance of a bar room, which I find is slowly and steadily, even in the Bombay High Court, where I'm a product of the appellate side, and so is His Lordship Justice O. We take pride in saying that we are products of the appellate side of the Bombay High Court. Now, what happens on the appellate side? What happens in the bar room? Bar room is a place where we get to rub shoulders with all the senior lawyers who are sitting here. And it is there that the senior lawyers watch your conduct. They watch how you are doing in the profession. When you are in an open court hearing, there have been times as junior lawyer when I have faltered so many times, and even thereafter. I must give you an example where I was appearing in one matter before Justice Lodha, and he was hammering me left, right and center. Fortunately for me, one senior lawyer of the Bombay High Court was sitting next to me. He was pained by what was happening. And during lunch recess, he came up to me and told him what is happening is not correct. And he gave me that confidence. He told me these are the submissions you have to make. Please make your application in this particular format. The senior happened to be Justice Oak. Now this is what happens in an open court hearing. I'm sure your Lordship will remember that incident. It happened in courtroom number 40. Had it been a case I had appeared through video conferencing, where would that have left me? No senior to guide me, nothing. I would just have argued in the camera, blabbered a few things, taken a hit from the senior judge, and that is it. But then in the afternoon, suddenly the tables turned and the judge could see my point. That is because we got that assistance. Now this is what happens when you are in a bar room. There are seniors who will always see, they will ask you, what are you doing? What are you reading? You can go up to them. Now what happens when you all have your swanky offices? The seniors are in their offices. They are comfortable attending through video conferencing. Where does it leave the junior lawyers? This is where I am really concerned with. And when you bring in technology, the technology has to be only after you are well trained as a lawyer. This is what I would like to emphasize, and therefore I would urge that before you adapt to technology, please adapt to technology, but before that, first inculcate the best practices of this profession. Now I'll give you an example of, and I'll join issues with what His Lordship Justice Abhay just said about the great legendary Mr. Nani Palkhiwala, about his qualifications. Now, do you need to be highly qualified for delivering justice? According to me, for the purpose of delivering justice, one must have a robust common sense, which is not very common nowadays. Now, there was this Chief Justice of India who thought I must have a feeler of what happens at the ground level. So he thought that I must go around the villages and see how the justice is being dispensed with at the village panchayats by the panchayats and all. So he went to one particular Gram Panchayat and he saw the Sarpanch of that village. He was resolving the disputes within no time. The Chief Justice said, well, they have tremendous faith in this Sarpanch. So he said, this Sarpanch is very honest, his word is respected, and he is very fair. These are the attributes of a judge. And then next point he said, but well, he has nothing with him. See, he said, that is the reason why justice can be dispensed with so fast. Because he doesn't have statutes, he doesn't have rules, but he has robust common sense with him. And he has that independence and he has that fairness in him. These are traits and attributes of a good judge. Well, as lawyers, you have all these statutes, all the rules, everything with you. Please be abreast with all the facts. In the morning, all of you must have heard His Lordship Justice Oak speak about how the lawyers should train themselves, the young lawyers should train themselves. And this is where we have to inculcate these best practices in us as lawyers before we really venture into this adventurism of technology. When I say this with a full sense of responsibility that something that has been gone on in open court hearing for times immemorial should not be tinkered with, and the very foundation of this system, getting disturbed in the process. We must think about this for the future as well. Bring it very slowly as possible. Now, since young students are here, I would just like to, drift away slightly and put something to you. Please treat this as an exercise. When as lawyers, you have to, you have to think on your feet, as Justice Oak had said in the morning. Secondly, you have to look at the matter from different dimensions. There are n number of dimensions a matter can be looked at. Now, from the social perspective, I would present one case which was, it is a case which was argued in the Bombay High Court. The facts were somewhat like this. There was a very good family, a family comprising of a husband, wife, and a child 8 years old. Now the husband would go out for work in the morning, come back late at night. Sometimes he would be away for 3-4 days. Unfortunately for the wife, she developed a fondness for a neighbor with whom she had an affair. Now, one fine day when the husband was not there, the neighbor, the wife, and the son, they went to one park. And at the park, the son saw something. Now, the son was very disturbed. Now, seeing that, both of them panicked suddenly. And to save himself, the neighbor, he killed the son, then and there in front of the mother. The mother became unconscious. Now, after she becomes unconscious, the neighbor runs away. The police come, investigation starts. Then the mother gives a statement, this is what has happened. The neighbor is arrested. Over a period of time, what happens is, the parents of this lady, they desert her, saying that you have taken away our grandson from you, you are a wretched lady, and henceforth we have nothing to do with you. Now the man is inside in jail. He sends a message, look here, there is nobody to look after you, I am the only one. So now what you do is, you turn hostile. Now she is in a position where she doesn't have anybody to look after her. He is taking the advantage of this situation. The parents have deserted her. Ultimately, she goes to the court, helpless lady goes to the court and turns hostile. She says there were some other persons also, and this gentleman was always with me. There's nothing he has to do with this murder. And he walks away scot-free. What I want you all to think in this is, who is right in the process? Is this lady who deposed against her own son is right? Are the parents right who deserted the lady when she wanted her most, when the daughter when she wanted the daughter when she needed the parents most? Or is it the husband who influenced her? Is it the society which didn't protect this? This is something, as law students, you have to think about the matters from different dimensions, and this is what the beauty of this profession is. And therefore, though there are national law schools, you will get good pay packages, you will all be immediately engaged in corporates. I would implore and urge you, please come to this profession. This profession is very dynamic. There's a liveliness every day. You can do a lot for the society. And the future has a lot in store for all of you. There's ample space for all of you. With this, I'll conclude and leave it to His Lordship. Thank you so much.
I request Mr. Devidas Pangan, Advocate General, to express his views.